Hello, my name is Peter. I'm the Director of Student Advocacy and University Affairs at the Legal Information Clinic at McGill, and today I'm going to be giving you a presentation about your student rights as a student at McGill University. So the first thing we're going to be looking at is what our role as the Office of Student Advocacy, what we do. We're going to be going over how that can help you in the various different situations you might be kind of getting into. We're going to be covering what a grievance is in the event that you have an issue with McGill University. And we're also going to be going over your specific rights as a student under the Charter of Student Rights. And we're going to go through the procedures related to a disciplinary offense in the event that you're ever accused of something like, say, plagiarism. So student advocacy has been part of the LICM for over 30 years. Normally we'd have a photo of our whole team up here, but unfortunately due to COVID-19, we're not able to have a full team photo, but normally we're a team of about 20 volunteers that help take care and help you with any issue you might have with McGill. So who kind of makes up the team? Well, there's the Director of Student Advocacy and University Affairs, my role that supervises and manages the office and makes sure that everyone, is assigned their cases and works well. There are the senior advocates that help manage our juniors or volunteers, and they assist me in delegating cases and figuring out who will take care of them. And then there are the junior advocates, probably the individuals that if you need help, you'll be interacting with, who advocate on your behalf in various cases. So what specifically does student advocacy do? We advise, represent, and negotiate on behalf of students who are facing disciplinary proceedings or having difficulties with the university. And you might be asking yourself, well, what's the difference between, say, student advocacy and the LICM? We provide advice on McGill policies. So we can kind of give you direction on what might be the best path for you when it comes to the Code of Student Conduct and Disciplinary Procedures, the Code of Student Grievance Procedures, anything related to, say, harassment, sexual harassment, or discrimination. These policies also specifically usually allow for you to have an advocate who can either speak on your behalf or provide advice so you can better understand them. But we do not provide legal advice or information, so we can't comment on how this might affect the broader world, what happened to you. We can only talk about those McGill policies. If you ever have a question that's kind of outside of that, it's more in the legal sphere of how this works in Canada, that's a question better addressed for the LICM. There are a lot of different policies that we can deal with at student advocacy. This brief list is just kind of some of the ones that can come up in terms of what might be relevant to you during your studies at McGill. So it's not just a question of like the Code of Student Conduct or grievances. It can also be questions about your rights as a student, with the Office of Students with Disabilities, the OSD. It could be about intellectual property if you're doing work, researching and you want to make sure that that work is your own. Anything related to harassment, discrimination, also the university student assessment policy. So in the event that you're not satisfied with the grade that you receive. And if you ever have an issue, it's always better to come to us and we can figure out whether or not it's within our purview and something that we can offer you help with. So our advocates can often appear at a variety of different hearings. We can appear at disciplinary interviews. We can appear at the Committee on Student Discipline hearings. That's the more serious version of a disciplinary interview. There are appeal hearings for a variety of different issues. We can also represent you in any kind of faculty promotions committee. So that's normally, say, for something like medicine when it comes to being allowed to stay in the program. There are grievances, as well as kind of interdisciplinary resolution. So any kind of issue where you're meeting with a university official and you'd like to have someone with you who can kind of speak on your behalf and know the policies as well. So you might be asking yourself, well, what is a grievance? A grievance is a formal process by which a student can seek redress for an infringement on their rights by another member of the university committee. Grievances must be grounded in the Charter of Student Rights. An important document that kind of analyzes everything that you have as a right to a student. Any student believes that their right has been infringed by a member of the university community has the right to lodge a grievance. So that could be a professor, an administrator, or another student. An infringement can be an act or a failure to act. So that doesn't just mean someone who did something towards you, but also someone who maybe failed to offer you something. Former students may lodge a grievance so long as the violation happened while the person was a student. So in the event that you graduate from McGill and afterwards you realize that maybe something happened to you and you weren't happy with it, you can still come to us and we'll help you with that. And like I said, if there's anything where you're not sure and you think, well, maybe this is something that's relevant to me, come to us and ask your question. We're happy to take a look at your issue and see if there's anything we can do to help. So what are some of your rights as a student? This is a non-exhaustive list, but the Charter of Student Rights outlines several specific rights. You have a right to equal treatment. You have a right to be free from vexatious conduct or violence. You have a right to a quality education. You have a right to fair and reasonable evaluation. You have a right to adequate graduate supervision. You have a right to full, equal, and fair hearings. You have a right to consult any record of personal information at McGill. You have a freedom of association, and you have freedom of opinion, expression, and peaceful assembly. So it's important to note that also in a lot of other documents, say for example, under the Student Code of Conduct, that you also have additional rights to that. For example, if you are called to a disciplinary interview, you have a right to remain silent. You have a right to have an advocate with you when you're at the meeting, and you have a right to view the evidence before the hearing. So you really need to come to us to kind of get a full picture of all the different rights that might apply under different policies. So what are some common misunderstandings when it comes to student advocates? There can be a false understanding that we provide legal advice. We focus on the policy and we provide advice on these McGill policies. But we slow down the process. Usually we can help try to find the right person to instead go to ideally make it so your matter is heard quicker, rather than necessarily waiting and going down the wrong path and talking to the wrong university official. We push students to escalate our issues. That's not really it either. We do our best to try to encourage you to talk to the right person to deal with the problem before you even go to a grievance or something like that. We do our best to try to make sure that you have an informal resolution that gets you the result you want sooner, rather than waiting for a longer decision process. Create reprisals for students. Again, you have a right to an advocate under a lot of these policies, and a university official will never hold it against you for bringing us into a meeting with you, say if you're at a disciplinary interview. It doesn't imply guilt by us being there. And then we hold strict privilege. It's important to emphasize that we're not lawyers, so we don't necessarily have the same legal standards. All your information that you give to us is confidential. It's just that we wouldn't have the same solicitor-client privilege that you might have if you had a lawyer. It's important to emphasize. So you might be asking yourself, what happens if you get accused of a disciplinary offense? And I'm going to give you kind of a brief example. This one's technically in the arts section, but you never know, in engineering, this still applies. Jemma is a first-year student taking a history course. She's required to write a paper as one of her assignments. While writing it, Jemma copies some sentences directly from a textbook. After submitting the assignment, she receives an email from her faculty asking her to attend a disciplinary interview based on a violation of Article 16A, which is plagiarism, of the Code of Student Conduct and Disciplinary Procedures. Jemma is going to be wondering what she should do. And if you were in a similar situation to her, you should reach out to Student Advocacy. We guarantee confidentiality. We operate under a code of ethics when working with students to make sure your information is never shared. Only the senior advocate or the director, so me, would have access to any of the information. We would be the one who would be doing the intake for your case, and only your junior would be aware of the full details. And, you know, we would be able to kind of give you a little bit of guidance and kind of explain the whole process to you. So what would happen next? Jemma reaches out to Student Advocacy. A junior advocate has now been assigned to her case. She asks her advocate what will happen next. And this is the point where it can get complicated, because depending on the facts of her case, it can take a variety of different turns. So disciplinary offenses in general can go in a variety of different ways, as you can see from the slightly complicated chart. You know, we're going to be focusing really on the disciplinary interview, but it's important to note that all of these different paths can occur within a case. As you can see, can kind of circle back to a committee on student discipline. And that's the more serious element, which you have the option to appeal to in the event you're unhappy with the outcome. But we're going to be focusing on the disciplinary interview here. So now that Jemma, Student Advocate, has explained the process of a disciplinary offense accusation to her, she's a little bit nervous about attending her disciplinary interview, but she is wondering how to prepare for it. She asks her advocate what will happen during the interview. So to break down the process, a disciplinary interview usually includes a disciplinary officer, student who's being accused of violating the Student Code of Conduct, and usually a student advocate. The disciplinary officer can also have an advisor, say the professor for the course, present as well, but generally it's going to be the three of them. The disciplinary officer is required to inform you of your rights, so your right to remain silent, your right to have an advocate present, your right to view the evidence, and then the disciplinary officer will usually present the evidence and invite the student to speak and kind of explain to see if there was a misunderstanding or to better understand the situation and understand the circumstances that led to the alleged offense. These interviews are really informal, and they're more of a conversational approach that allows the student to kind of explain everything and for the disciplinary officer to understand the narrative events that led to it, so they can really keep that in mind when they come to a decision on the outcome. So there are three major outcomes that can come from a disciplinary interview. The first is an exoneration, which means that there was not enough evidence to find you guilty of that. That's basically the not guilty outcome, you know, in the sense that There's no additional punishments. You're free to go. It'll never be held against you. That's it. There's a second tier, which is admonishment, which means that there was sufficient evidence to find you guilty of the academic offense. It is an official sanction, but it does not result in a record. So that means that in the event they say you're applying for a master's or any other program later on in life, this is not something that would follow you around. This is just there in the event you're accused of another disciplinary offense. So if you're accused of plagiarism for a second time, it will be treated a little bit more seriously because this is your second time being brought before an interview. Finally, there's a reprimand. That's the most serious one, again, meaning that there was sufficient evidence to find you guilty, and it is an official sanction that does result in a disciplinary record. It's important to note, though, that that disciplinary record is confidential, and you have to consent in order for it to be revealed. So in the event, say, you did apply for a master's or any other kind of program, McGill would have to ask your permission before they send that record, and you have the right to say no. It's important to note that in order for evidence to, be found sufficient, the evidence has to be clear, convincing, and reliable, as according to the Student Code of Conduct. And that means that then once that threshold is met, then that is when you'd be found guilty of either an admonishment or a reprimand level punishment at a disciplinary interview. So what would be the likely outcome of Jemma's interview? It's important to note that for the facts of this case, it's been kept vague. So that means that depending on a lot of different circumstances, it could lead to different outcomes. But it's very likely that Jemma would be admonished based off that evidence. And Jemma is also worried about the additional penalties that might accompany that official sanction. So she asks her advocate if this is a possibility and what those likely outcomes are. So there's a variety of different additional penalties that can be imposed at a disciplinary interview. The most common one that's usually imposed is conduct probation, which similarly to an admonishment or a reprimand, just means that in the event you're accused of this, again, that then you are likely to be held responsible, and treated as a more serious offense. In the event that, say, there's another disciplinary event, say this occurred in residence or something like that, it can often be accompanied by other punishments, like, say, 10 hours of unpaid non-academic activities. So somehow community service, volunteering to make up for whatever occurred there. Another example could be suspension if it's a serious enough offense. There's security for good behavior, there's exclusion of residence for a specific time, again, all depending on the different scenarios that might have occurred. It's important to note that in an academic offense, it would likely be a grade of 0 on the assignment. That's the most common one that could be associated with something like, say, plagiarism. There's also the possibility that you could fail the course if that assignment was required to pass. But again, that would depend on the specific evidence and what did occur and what level of plagiarism did happen. If the entire assignment is copied, then that might be different than if there was, say, a misunderstanding in citation. So I know that was a very brief outline to give you an idea of kind of how these different processes work, but if you do have more questions about your student rights, and if there's anything that I kind of talked about that you'd like to learn more about, feel free to reach out to our email, info.studentadvocacy@licm.ca, and send an email, send a question. We're happy to set up an intake call with you and discuss further. Or if you're just curious in general, we're happy to help out and to give you more information. I hope that you found this presentation informative, and I hope you have a great rest of your frage.